Okay, ladies and gentlemen, while I struggle with the technology, I should, whenever I talk about Brexit, I am trying to make a point to reveal my biases. As someone who's lived and worked in this country for 15 years, Brexit doesn't leave me cold, and therefore I need to just briefly sort of reveal that what you might hear is not completely sort of the sober academic. This is colored by the, dare I say, Brexit victim perspective. On the other hand, as someone who some years ago wrote a textbook on WTO law, I feel there is some opportunity to shed some light on where we are in the process and what else might come. We have people in the room who are much better qualified to assess where the UK Parliament is going to end up in just a second, because I think if someone had said to me 3 months ago that we still wouldn't know what exactly the consequences would be, I would have said that is absolutely impossible in a well-organized country like the United Kingdom. Unfortunately, that is exactly where we are. And that is, I think, to a certain extent, the problem. Let me re-put my PowerPoint slides. Does anybody know how to show this slide? Yeah? Oh, it's not ideal. Have you download? Yeah, I tried that just now. There we go. Good. Okay. Ladies and gentlemen, what is the effect of the Brexit process on the UK's ability to conclude trade agreements, and what are the potential frameworks? So you've already heard that one of the purposes of Brexiting is so that the UK can enter the glorious space of negotiating very beneficial free trade agreements with other countries. And we shall see whether that is possible. The main claim I think I would like you to take home from my presentation today is that I feel that in both negotiating the political declaration and maybe even the withdrawal agreement, both sides, the UK government and the Commission, have sort of slightly ignored the over 40 years of case law on EU external relations. What can the EU actually agree to when it interacts with other countries? Now, some colleagues say the withdrawal agreement is such a special agreement. Yes, it's formally concluded as an international agreement, but it should be seen as some special sui generis kind of legal act. I sort of disagree with that assessment. When I voiced the opinion 2 years ago that I think if the Court of Justice ever looked at the withdrawal agreement, it would find it breaches EU external relation principles in many places. I was basically shouted down as, some big Brexit skeptic, not seeing the opportunity. On the other hand, I think the Commission was very much driven by the action of negotiating the withdrawal agreement, not really assessing every single provision in terms of the possibility of a legal challenge under the EU legal framework. Why am I saying that? Because the Court of Justice in recent times has sort of reasserted the tendency it showed in the early 1990s to say the autonomous legal order needs protection. Right? If you conclude an agreement that impacts directly on our autonomous legal order in some shape or form, then there are legal barriers that even if the Commission wanted to, cannot cross. Some might find the language quite surprising that the Court of Justice used in the Acmea decision, right? But it speaks, I think, volumes also when we assess what is actually possible, what can the UK negotiate with the EU without impacting on the EU legal order. And that is, I think, an understudied, underestimated challenge that comes on top of all the other Brexit challenges. So my conclusion for you is Brexit, even 14 days before the 29th of March, remains a really bad idea. The common commercial policy, right? The UK seems to negotiate or has made an attempt to negotiate the political declaration as if it were not aware of what the constitutional constraints are on the EU legal side, right? Very early on in the Brexit process, we had ministers stand up saying, Germany will never allow the Commission not to give us what we want in our trade negotiations. Any legal experts and most of the UK lawyers of the last 20 years have had EU law as a mandatory subject, just shook their heads, right? Where does this dearth of understanding in the UK institutional framework come from? I really wonder. Anyway, it's an exclusive competence, right? The member states take the back seat in these negotiations. It includes foreign direct investment services, intellectual property. It must comply with the foreign policy objectives in Article 21. Luckily for the UK, in the Singapore opinion, opinion 2 of 2015, the EU exclusive competences were interpreted widely, with the effect that we have already a free trade agreement in force with Japan, even though we negotiated it only sort of 2 years ago. George alluded to opinion 1 of 94 and the WTO agreements originally were seen as mixed agreements. I think it's very clear that if the political declaration were ever negotiated, there would either have to be two separate negotiations where the mixed aspects are in a separate agreement and the exclusive aspects are in an association agreement with the United Kingdom, or otherwise it would be a mixed agreement which would require ratification by the 37 parliaments around the European Union 27. Consequently, EU member states are not allowed to strike their own trade deals, and it is, in my view, highly questionable whether the EU has the competence to form a combined customs territory as envisioned by the political declaration. The EU can agree a customs union as part of an association agreement, but again, there's a big question mark whether the instrument, the competence for an association agreement, is actually applicable to a former member state with which you want a free trade agreement. So how does EU external relations law limit what the EU can agree after Brexit? I've already said that I think the withdrawal agreement is an international agreement which follows special rules. But I think it's very difficult to disregard the EU external relations jurisprudence. In my opinion, normal EU external relations law applies, which in turn would even turn the transition period legally doubtful, as in my view it affects the autonomy of the EU legal order. And we've seen in the first opinion on the EEA agreement that even if you have exactly the legal text, and George explained that very well, I thought, the EU Court of Justice doesn't regard it as equivalent because, of course, the enforcement mechanism and the entire context in which these rules operate, right? Even with the withdrawal bill, we have converted all of EU law into UK law. Same text can be interpreted differently. That is enough to not regard it as equivalent. Now, everybody says, and in Parliament yesterday I listened to some of the debates, we shouldn't be worried. It's not really no deal because we have WTO membership. As if that was the trump card that the mighty United Kingdom can put on the table in every negotiation. No wonder the EU Commission officials are left confused and slightly irritated. Because if anything, there are two problems with the WTO membership. First of all, the UK's WTO membership and the terms of that membership are not certain. And on the other hand, the WTO membership is just a basic minimum and doesn't allow for any special deals or mutual recognition or anything that a modern, thriving economy needs to relate to other countries. So the UK is a founding member state of the WTO. It joined the WTO as part of the European communities. Only the EU has currently valid WTO schedules, which have to be negotiated. And the UK government is determined that there will be no negotiations as it plans to reissue the EU schedules, changing the name and minor editorial changes. There is a huge discussion as to what to do with EU quotas, in which the UK participates, agricultural subsidies, service liberalization, and existing trade defense tariffs. I just wanted to interject that in parts of the UK institutional structure, there is actually a lot of knowledge, there's a lot of understanding on these trade issues. The House of Lords European Union Committee has issued fantastic reports, which I think, either members of the House of Commons are too busy or they don't read or, I don't understand how someone can stand up in Parliament and claim that on the one hand, you can have free trade with no restriction, and then on the other hand, you don't face any limitations in your sovereign decision-making. This was already cleared up, in my view, in 2017 by a very good House of Lords report, which said that the notion that a country can have complete regulatory sovereignty while engaging in comprehensive free trade with partners is based on a misunderstanding of the nature of free trade. Modern FTAs involve extensive regulatory harmonization in order to eliminate non-tariff barriers and surveillance and dispute resolution arrangements to monitor and enforce implementation. I leave the rest for that. So where we are with WTO membership, we are in legal limbo. Why are we in legal limbo? Because the certification of the schedules has hit a roadblock. And everybody predicted it would hit roadblocks. The certification should have been concluded 45 days, but the services schedules are being blocked by inter alia Russia. Costa Rica yesterday withdrew its objections to the certification of the services schedules, but Russia, I think, is hoping for real negotiations with the United Kingdom. And of course, if the United Kingdom were to offer negotiations, it probably would have to offer negotiations to all countries. On the good news side, on the 27th of February, so some days ago, the UK got the permission by the Committee on Government Procurement to accede to the government procurement agreement. This membership was blocked by inter alia by Moldova because the Moldovan trade minister wasn't given a visa by the Foreign Office to actually hold talks with the UK government. This level of could I call it incompetence? It's just flabbergasting. And yesterday, Mr. Rees-Mogg, the Member of Parliament for, I think, Southern Devon or somewhere, spoke up and said, we shouldn't be worried because there's Article 24, which gives us 10 years to trade on the same terms with the European Union as before, right? All we need is an agreement from the Commission that we are indeed in some form of trade negotiations. Well, this myth that there's a sort of golden way out of the no-deal Brexit quagmire is absolutely wrong and has been dispelled numerous times. Right? The great Steve Pearce said, if Rees-Mogg thinks that the clause on an interim free trade deals in Article 24 GATT applies in the event of no deal, he's profoundly confused. It is exactly the opposite. Right? This Article 24 is designed as a stepping stone to freer trade. So if you have no trade deal with any other country and you enter the trade deal, you can trade more freely than you did before while you negotiate the final regional free trade agreement. And not understanding that Brexit will restrict trade and therefore will not be in conformity with Article 24 is weird to me. The former appellate body member for the United States, Jennifer Hillman, tweeted yesterday that she thought there were multiple violations in the unilateral tariff schedules that the UK government published yesterday. They were in violation of WTO law, especially because the UK government is proposing that all these safeguard tariffs that the European Union has and the anti-subsidies tariffs could be sort of rolled over in the case of a no-deal Brexit. That is not possible because under the WTO, every country needs to do their own anti-dumping, anti-subsidies negotiations. Well, we have the Trade Defence Institution in the UK, and its head has just been appointed for the 1st of March. Unfortunately, this office has currently no staff and no institutional capacity to do wide-ranging in situ investigations of whether China is subsidizing or dumping its solar panels onto the UK market. So the UK national economy in legal terms, in WTO legal terms, is in for a very rough ride because the country is absolutely unprepared for what even just WTO law will require it to do. Yeah, my absolute favorite topic and one of the, Lord Lawson famously said on the radio 2 months before the Brexit referendum that nothing will change with Brexit. None of our trade relations will change because the UK is a full party to all the EU free trade agreements, right? So it has these free trade obligations as part of the EU, and because it's a contracting party to these mixed agreements, we shouldn't be worried at all. Well, that was the starting point with which the newly formed Department of International Trade went to the over 40 free trade partners of the EU, saying, please just roll over the existing obligations into the post-Brexit period. Well, suddenly, as experts, I dare say, predicted, this turned out to be much more complicated than the government expected, right? Because these are essentially bilateral commitments between the EU as a bloc on the one hand and the trading partner on the other hand. So none of the bigger trading partners was immediately prepared to give the UK, which is a much smaller market, I think in fact that needs to be pointed out to some MPs, exactly the same rights that these trading partners gave to the much bigger partner, which was the European Union. So by March 7th, only six agreements have been signed with Chile, Switzerland, the Southern African Development Community, the Faroe Islands, Israel, Liechtenstein, and the Palestinian Authority. Right? That leaves over 34 existing EU FTAs unreplicated, as well as hundreds of other agreements that are not being rolled over in the case of a no-deal Brexit. So this will disproportionately impact some of the other nations of the United Kingdom. As I pointed out in my blog 2.5 years ago, the Scottish protection for Scotch whisky is dependent on EU-only agreements in some of the biggest markets, Australia, the US, Canada. And if you lose that kind of protection, it will have a devastating impact on certain parts of the UK economy. Just to say that politicians had actually promised this rollover without any hiccup. The junior trade minister, Mark Price, said in October 2017 that virtually all of the EU's existing partners had in principle agreed a rollover. No, what they agreed to was to talk to the UK about future trading relationships. They didn't agree to the kind of rollover agreement that the UK got with the Faroe Islands, right? These are very short agreements because it only requires 2 paragraphs. The UK agreed with the Faroe Island to apply the terms of the EU Faroe Islands Agreement, mutatis mutandis, right? So, and then some special agreements on rules of origin, which is also a very, very difficult, very technical topic, which will hit this country really hard. So where are we with the rollover promise? Nowhere. Yes, and there are real legal doubts that the UK tariff list for the no-deal scenario is actually legal under WTO law. The UK agreed not to control the goods that are crossing the border in Ireland and thought that was a really clever move in order to, show that it is committed to keeping the Irish border open and thinking that this could be done without any agreement with the European Union. Well, experts such as Holger Hestemeyer have pointed out that this is probably a most favored nation violation. It could, in his view, potentially be justified with the national security exception. In my view, there's no such justification possible. And so the no border checks in Northern Ireland creates a double 2F MFN problem through the de facto discrimination that, though it might be justified. I think Eleanor talked about de facto discrimination not being seen as such by the UK government. And maybe that's something for UK constitutional lawyers to pick up on. I see de facto discrimination in the entire Brexit process almost everywhere. Steve Pearce also pointed out that there's no such thing as a principle of continuity when it comes to, for example, rules of origin. So just because you were allowed to call your product an EU product, once you've Brexited, you can't then hope for a continuity of that determination of the rules of origin. So there's no principle of continuity in treaty law which would cushion the no-deal Brexit and the devastating impact on the rules of origin. Now, maybe because I'm an EU migrant, I don't see the promise of the UK striking its own trade deals out in the world, right? Maybe the biggest prize is actually in a sort of customs union with the United States of America, or participating in the US internal market. Well, none of those promises is on offer. We already know the specific negotiation objectives, and they are one-sided, right? This is what if you compare the language of these negotiating objectives with the ones that the US proposes for the EU, the ones for the EU are more a negotiation of equals. These are very similar to the negotiation objectives that the US uses for minor players and smaller countries. And what is the US proposing? Well, they want a free trade agreement with the UK, all right, but they don't want to accept any of the UK standards for their own domestic markets, and they want that the UK accepts all the US standards. And I think Georges already alluded to the fact that they want to insist on science-based decision-making, which is the code word used in the US to undermine the very strict application of the precautionary principle in the European Union. I particularly love the GMO food, right? So the US thinks because GMO foods are widely sold in the US, they must be safe. And the US ambassador even said the instances of food poisoning are much lower in the US because the food is much safer in the United States. That is, of course, complete rubbish. The food standards are much higher in the European Union. And if we needed more evidence, well, the negotiation objective here says, crack open the very strict food quality standards by the EU, and of course, get rid of any restriction on GMO, GMO meaning biotechnology, which the EU is very skeptical about. Yeah, I'm hesitant to show the slide. It hasn't aged well. I should maybe replace it with the political declaration. All I wanted to highlight is that some of the red lines that the current government has set out, in my view, violate legal principles that can be found in EU law. when I showed this slide to some of my students, there was strong disagreement. I think this is maybe the most negative view on some of these red lines. I think what is problematic, to pick up one point, is that if the rule book comprises many single market rules, as a non-EU court is allowed to authoritatively interpret those EU rules, that is inherently problematic for the Court of Justice. So this idea of a common rule book sounds good, but if there is a binding interpretation given, I think not having a mechanism that involves the Court of Justice would fall short of EU law as it stands. Now, my students then said, well, you could always change the EU treaties. And that is maybe the final point. I think the UK has lost so much political capital in the last 2.5 years that the possibility that the EU 27 would change the treaties and the legal foundation in order to accommodate the Prime Minister May's red lines is so remote that I think it would be easier to prove that the EU is trying to trap the UK in the backstop, which is already almost impossible to prove, than that the EU 27 would change the treaties. What can I say? I feel a little bit like George's cartoon. I'm sick and tired of the political class in the United Kingdom not realizing that the very best deal the UK has is the current one. Thank you very much.